My name is Natalia Lusak. I'm a staff attorney in the Immigrant Protection Unit and New York Legal Assistance Group. Today I'll be discussing deferred action for childhood arrivals, also called DACA, in preparation for the upcoming DACA clinics. So to review the agenda, I will start with an overview of what DACA is and what it is not. Then I will discuss the criteria that make someone eligible to apply for DACA. Next, I will discuss the application process, including the forms and how to that have to be filled out and supporting documents. I will also discuss how criminal history may affect a DACA application and what to look out for. I will give the mailing address to which DACA application should be sent and fees that must be included with the application. Next, I will discuss how to renew a DACA and when someone is eligible to do so. I will then discuss what happens after a DACA application is submitted. I will talk briefly about the consequences of lying on an application, and lastly I will talk about travel outside of the United States for approved DACA recipients. We will also have some time for a question and answer session after the presentation. So I'll start with a little historical background. Since August 2001, Congress has been stalled on passage of the DREAM Act, DREAM standing for Development, Relief, and Education for Alien Minors. This act is intended to give childhood arrivals a pathway to citizenship. On June 15, 2012, President Obama took executive action and ordered deferred action for certain young people who came to the United States at a young age. This executive action granted DACA recipients to become low priority to be deported from the United States. However, to be eligible for deferred action, requesters must meet specific criteria. Each case is individually reviewed, and a grant of deferred action is not guaranteed. Deferred action lasts for a period of 2 years and is subject to renewal. I want to be clear that deferred action is not a legal immigration status. It does not lead to a green card, it is not a path to U.S. citizenship, and it is not a permanent resolution to an immigration case. In fact, after deferred action expires, the Department of Homeland Security may still continue with a deportation case. Despite its limits, there are several benefits of deferred action. As I mentioned already, deferred action is valid for 2 years, and during that period, an approved DACA requester becomes low priority to be removed and is protected from immigration proceedings or deportation for up to 2 years. Deferred action can be renewed after this 2-year period. Deferred action also makes someone eligible to receive an employment authorization document, or EAD, which is a work permit, if there is a demonstrated economic necessity for them to work. While an approved DACA requester does not have legal immigration status, he or she will not accrue unlawful presence while in the period of deferred action. This can be very helpful if the DACA requester tries to apply for any type of immigration status in the future. An approved DACA requester is considered PRUCOL, or permanent resident, under color of law, and this makes them eligible for New York State benefits, public benefits such as Medicaid. However, they are not eligible for federal benefits. In addition, an approved DACA requester can also get in-state tuition in New York. So now we'll talk about the criteria for eligibility. President Obama's executive order states that a person requesting deferred action should have come to the United States before his or her 16th birthday. They must have continuously resided in the United States for at least 5 years before June 15, 2012, meaning since at least June 15, 2007. They must have also been present in the United States on June 15, 2012, and they must not have been over the age of 30 on that date. They also must not have had a valid immigration status on June 15, 2012. They must currently be in school, have graduated from high school, or have obtained a GED or a GED certificate, or they must have honorably been discharged. They must be an honorably discharged veteran of the Coast Guard or armed forces of the United States. And finally, they must not have been convicted of a felony offense, a significant misdemeanor offense, multiple misdemeanor offenses, 3, or otherwise pose a threat to national security or public safety. I will discuss these requirements in more detail in the following slides. First, I want to discuss the forms that must be submitted to apply for DACA. The required forms include a Form I-821D, which is the application for consideration for DACA. It must also include the Form I-765 application for employment authorization. Please note that question 16 on this form asks for what's called an eligibility category, and for DACA it is C33. You must also have a Form I-765 worksheet. There is a portion where you write a brief statement about the requester's economic need for employment authorization. In addition, a Form G28, which is a notice of entry of appearance, is required for requesters who will be taken on for direct representation by NYLAG. However, it is not needed for those who will be filing their applications pro se or without the assistance of an attorney. The application must also include supporting documents that show that the requester meets the eligibility requirements. Now I'll discuss what types of documents need to be submitted later on. The application must include a filing fee of $465, and the exact amount must be filled out on either a check or money order. If the amount is off by even $1, USCIS or U.S. Citizenship and Immigration Services will reject the application and return it to the requester. So please make sure that the correct amount is on the check or money order. The check or money order must also be made out to U.S. Department, spelled out, of Homeland Security. So once again, it's U.S. Department of Homeland Security. The application must also include 2 passport photos attached to the Form I-765. Make sure to write the requester's full name and date of birth on the back of the photos so that if for whatever reason they get separated from the application, the USCIS official knows whose photo it is. Finally, if the requester wants to receive an email or text notifying them that their application was received, they must also submit a Form G1145. So now I'll discuss in more detail the eligibility requirements and supporting documents that should be submitted with a DACA application. I will begin with the age and physical presence in the United States requirements. So the requester must have arrived in the United States before reaching the age of 16. If the requester arrived even on their 16th birthday, they are not eligible for DACA. The requester must not have been above the age of 30 on June 15, 2012. So in other words, they have to have been born after June 15, 1982. The requester must also have continuously resided in the United States for at least 5 years preceding June 15, 2012. So in other words, they have to have been living in the United States since June 15, 2007 or before. Anyone who came to the United States after that date is not eligible for DACA. In addition, the requester must not have left the United States for an extended period of time since June 15, 2007. And any travel before August 15, 2012 must have been, in quotes, brief, casual, and innocent. That's meaning that the absence was short and within a reasonable time to accomplish the travel purpose. And it must not have been because of an order of deportation, removal, or order of voluntary departure. Those who have limited experience in immigration law may be unfamiliar with the term voluntary departure, but as a brief explanation, voluntary departure permits an individual who is otherwise removable to depart from the country to depart from the United States at his or her own expense within a designated amount of time in order to avoid a final order of removal. So lastly, the purpose of the absence or the actions while outside of the United States must not have been contrary to the law. There is not an exact amount of time for a trip that is considered brief, casual, and innocent. However, if a requester has spent more than 6 months out of the United States, please speak to a supervising attorney to get more information about how to proceed. Finally, the requester must have been physically present in the United States on June 15, 2012, which is the date that President Obama announced the DACA program. So to prove that you have met the age and presence documents, you must submit supporting documentation. The same documents may be used to prove more than one of the requirements. So to prove the requester's age, you can submit the requester's birth certificate with English translations. Any documentation that's in another language must be submitted with English translations. If the requester is not in possession of their birth certificate and cannot get one, it is possible to use a passport or other government-issued ID from their home country's consulate in the United States. There are a few ways to prove that the requester entered the United States before they turned 16. If they entered with a visa, they can submit a copy of their I-94 card or the little white card that is stamped to your passport when you enter the U.S. They can also submit a photocopy of their U.S. admission stamp in the passport. If the requester entered the U.S. without a visa or they entered without inspection, which is that is called, they can submit a bus ticket or plane ticket from the border to their destination, or they can submit a notice to appear or other documents from the Department of Homeland Security that would have a date that shows that they were in the United States before they were 16. Lastly, they can submit any documents listed on the next slide that are dated before the requester's 16th birthday. So this is a list that can be submitted to prove continuous residence in the United States since at least June 15, 2007 and physical presence on June 15, 2012. I'm not going to go through the whole list now, but the documents submitted should have the requester's full name, the date, and there should be something on the document that shows an address or location in the United States. So for example, school records, medical records, utility bills that you receive at your home, or bank statements, employment records. Even a marriage certificate or birth certificates for the requester's children can be sufficient and be used to demonstrate presence. We like to tell requesters to give at least 2 pieces of proof for each year that the requester has been in the United States, particularly with an emphasis on proving that the requester was here since at least June 15, 2007, and that the requester was present in the United States on June 15, 2012. These are obviously part of the eligibility requirements, so you really want to make sure that you can demonstrate the presence for that period, and specifically June 15, 2012. These 2 pieces of proof should not be from the same part of year, so meaning that if you're trying to prove presence in 2012, it's best to have documents from March or April, and then something from October or November. So you don't want to have 2 pieces from June, for example. And the more you have, the better it is. So if you can get more than 2 from the requester, then that's really great. So as mentioned in the previous slide, any of the documents listed here can also be used to show presence in the United States before the age of 16. Some requesters will use school records from elementary school, for example, to show that they were in the United States before they were 16. So proving physical presence in the United States for the required 5-year period can be the most difficult part of the DACA application. All requesters are here without status and oftentimes do not build the same records that a U.S. citizen or a lawful immigrant might build. So they might not have a bank account, or they might not use their real names on documents, particularly for people in their 20s who may not be in school anymore. It gets to be more difficult. So we encourage requesters to be creative with finding documents to show physical presence. Even Facebook or photos with timestamps from their iPhones that show location. Things like that can be used as well to prove presence. So the next requirement is that the requester must not have valid immigration at the time of their application, and furthermore, the requester must not have had valid immigration status on June 15, 2012. So this program is just for people who have no immigration status. Valid immigration status includes a work visa, student visa, investor visa, or even temporary protected status. If the requester entered the United States with a valid immigration status, they must show that it expired before June 15, 2012. So just to give an example, if the requester entered the United States on a visitor's visa, they can submit a photocopy of the stamp on their passport when they entered that shows the expiration date. Those visitor's visas usually last for only a 6-month period. So another requirement is the education or military requirement. The requester must either currently be in school, has graduated from high school, or has obtained a GED certificate. Or the requester must have been an honorably discharged veteran of the Coast Guard or Armed Forces of the United States. An honorably discharged veteran who has performed active duty or selected reserve service since September 11, 2001 can potentially naturalize. So if you speak with a requester who falls in this category, please speak with a supervising attorney. Some documents that can prove these requirements are school records, a high school diploma or GED certificate, or military personnel records. So for the purpose of DACA, currently in school can mean a few different things. So it can mean being in a public or private elementary school, junior high or middle school, high school, or secondary school. It can also be an education, literacy, or career training program designed to lead to placement in post-secondary education, job training, or employment where the requester is working towards such a placement. Or it can be an education program assisting students to obtain a regular high school diploma or its recognized equivalent, including a certificate of completion, certificate of attendance, or alternative award, or in passing a GED exam or other equivalent state-authorized exam, and that the program is funded in whole or in part by federal or state grants or is of demonstrated effectiveness. ESL programs generally do not count, but they do only if the program is a prerequisite for placement in post-secondary job training, or employment where the applicant is working towards such placement. So you must show that the program is a prerequisite for placement and of demonstrated effectiveness. The final requirement states that a requester must not have been convicted of a felony offense, a significant misdemeanor offense, or multiple misdemeanor offenses. So in addition, the requester must not pose a threat to national security or public safety. So I'll explain that some more on the next slide. So for immigration purposes, the term conviction does not mean what it does in the criminal context. It's a lot more broad. So a conviction can either be a formal judgment of guilt entered by a judge, which is the traditional idea or traditional definition of conviction, but it can also occur in situations where adjudication of guilt is withheld, where a judge or jury found the individual guilty, or even when an individual entered a guilty plea or nolo contendere, where the defender, which is where a defendant neither admits nor disputes a charge, serving as an alternative to a pleading of guilty or not guilty. And lastly, a conviction can also occur when a requester has admitted sufficient facts to warrant a finding of guilt. When these circumstances occur and a judge orders some form of punishment, penalty, or restraint on the individual's liberty, this is considered a conviction. So it's much more broad, even as you can see where the requester has admitted sufficient facts to warrant a finding of guilt. This is considered a conviction for immigration purposes and in the DACA context. Some examples of punishment could include a prison sentence, probation, community service, or even a fine. So, as I said, if a requester has admitted sufficient facts to warrant a finding of guilt, or even if they pled guilty and they have to pay some sort of fine, can still be considered a conviction. So a felony, just to give a definition, a felony is a federal, state, or local criminal offense punishable by imprisonment for a term of more than 1 year. A misdemeanor is a federal, state, or local criminal offense punishable by imprisonment for less than 1 year. So in the requirements, the eligibility, if we go back a slide, it says you cannot have been convicted of a felony offense, a significant misdemeanor offense, or multiple misdemeanor offense. So a significant misdemeanor offense is a new immigration standard established particularly for the DACA program. And to give the definition, it is a federal, state, or local criminal offense that is punishable by a maximum term of imprisonment of 1 year or less, but greater than 5 days. So it includes the certain crimes that are included within a significant misdemeanor offense are domestic violence crimes, sexual abuse, unlawful possession or use of a firearm, drug sales, burglary, or it can even be a significant misdemeanor, which I have not just listed above, where a person receives a jail sentence of more than 90 days. But even if the person is sentenced to 90 days but serves less than the 90 days, they are still ineligible for DACA. And finally, I'll go back to the slide again. As I said, we've just discussed significant misdemeanor offenses. Multiple misdemeanor offenses just means 3 or more offenses not arising out of the same act or scheme of misconduct. So that would have to be reviewed by USCIS, but generally not in the same day or not coming out of the same act. Minor traffic offenses, such as driving without a license, will not be considered a misdemeanor. So that will not make someone ineligible for DACA. So finally, the requester cannot pose a threat to national security or public safety. So this includes gang membership, participation in criminal activities, or participation in activities that threaten the United States. So even if technically a DACA requester is not barred because they don't fall into these requirements that make them ineligible, they could still be denied. Their DACA application could still be denied because the USCIS official will look at the totality of the situation and will determine whether they could potentially be a danger to public safety or national security. So as you can see, when it comes to criminal history, it can get very complicated. I just sort of gave you a brief overview, but if the requester has been arrested in the past, please make sure to contact or to consult with a staff attorney. It just gets much more complicated when criminal history is involved. And when you're asking if someone has been arrested, make sure to ask in several different ways because some people are a bit confused about whether they have actually been arrested. So ask whether the requester has ever been handcuffed, fingerprinted, had any interactions with the police, or has ever appeared before a judge. If the answer to any of these questions is yes, once again, please talk to a staff attorney to get assistance with the application. It is extremely important to get all information regarding arrests because some arrests can potentially lead to deportation, and we do not want to put the requester at risk of ending up in deportation proceedings. So if the requester is accompanied by a parent, it might be a good idea to see if they want to speak privately. They may not want to admit to their parents that they have been arrested, but as I've already said, it's really important to get this information. So if there's a parent there, it may be best to speak with the requester alone unless they're very young. In addition to the criminal questions that you ask and the other sort of screening questions, just make sure to ask the requester if they've ever been in immigration proceedings, and if they have, just speak with a supervising attorney to figure out any potential issues. If they have been ordered deported, they can still apply for the program, but it may make things a little bit more complicated. So just make sure to flag down a staff attorney and speak with them. So the Department of Homeland Security has stated that all requests for deferred action will be decided on a case-by-case basis, and all evidence will be reviewed in its totality. So once again, as I said, with the criminal issues, even if someone technically is not barred from getting DACA or receiving deferred action based on their criminal history, it will still be considered by the Department of Homeland Security in determining whether they're eligible and whether they will ultimately get deferred action. So there is no guarantee that requests will be automatically granted. As I just said, it's based on a case-by-case review. And unfortunately, a denial cannot be appealed. However, a requester may request a review of a decision by contacting the USCIS call center at 1-800-375-5283. So while there is a potential to review, you cannot appeal. So usually when you get a denial, it is more or less a final decision. Once the forms are filled out and signed by the requester and supporting documents are collected, the application must be mailed to the address listed here. So for U.S. Postal Service, it's just to the P.O. Box number in Chicago, and then for express mail, to the address listed below. Please note that these mailing addresses are for requests in New York. If the requester is from another state, they may have to send to a different address. So then you'd have to look at the instructions on the I-821D form to figure out where to mail the application. But for New York, it will be to the Chicago lockbox. So there is a fee for filing for deferred action, and it's $465. Generally, there isn't a fee waiver, but only in very, very limited circumstances can you request a fee exemption. This request for fee exemption must be filed and approved before applying for deferred action. So to apply for the fee exemption, the requester's household income must be less than 150% of the U.S. federal poverty level and be in one of the following categories. So the requester is under 18, homeless, in foster care, or otherwise lacking parental support. Or the requester is unable to care for his or herself due to serious chronic illness. Or finally, the requester at the time of application has accumulated $25,000 or more in debt in the past 12 months as a result of unreimbursed medical expenses for his or herself or for an immediate family member. So as you can see, these exemptions are very limited. So for the most part, people are going to have to pay the $465 fee. As I mentioned earlier, with the money order, it has to be the exact $465 amount written on the money order. As if it's off by even $1.50, the application will be sent back to the requester, and it will just prolong the processing period. So please make sure that is correct on the money order or check. So now I'm going to talk about DACA renewal. It has been a little over 2 years since President Obama announced the DACA program, so some people may now be eligible to renew the deferred action. An approved DACA requester may request a renewal if he or she met the initial DACA guidelines and did not depart the U.S. on or after August 15, 2012 without advanced parole. And I'll discuss advanced parole more in a minute. The requester must have continuously resided in the United States since they submitted their most recent DACA request that was approved, and the requester must not have been convicted of a felony, significant misdemeanor, or 3 or more misdemeanors, and must not otherwise pose a threat to national security or public safety. A requester should submit their renewal request about 120 days or 4 months before their current deferred action expires. However, if the requester submits their application more than 150 days or 5 months before their current period expires, USCIS may reject it and return it to them with instructions to resubmit closer to the expiration date. So if anyone comes to the clinics and it's more than 5 months before the expiration of their deferred action, they have to be advised not to submit their application until it is within at least that 5-month period. And certainly at the 4-month period to make sure, because there will be some processing time. It will take about 4 months for the application to be processed, so to make sure that the requester can get a new work authorization document before their current one expires, it is important that they submit their application within that 4-month period. In order to renew DACA, the requester must submit the same forms that they did when they applied initially. So that's the form I-821D, the form I-765, and the I-765 worksheet. Similarly, with the people who are initially applying for DACA, if they're being represented by NYLAG, then they must also sign a G-28. The fees to renew are also the same. It's $465. But the one thing that's different with the renewal is that the requester does not have to submit additional documents unless the requester has new documents involving removal proceedings, travel with advanced parole, or criminal history since they last applied for DACA. So that would include, with travel with advanced parole, then you'd want to include a copy of their passport and any entry or exit stamps that are in their passport since their last application. Documents that can be included in the DACA. So in addition to those documents that they've suggested, some other documents that can be included are the approval notice that they received from their initial DACA filing and a copy of the front and back of their work permit. That will just show the USCIS official that they have approved deferred action and that they already had work authorization previously. In addition to that, you would put the documents that I've already mentioned, anything relating to travel or criminal history. To indicate criminal history, you'll want to submit certificates of disposition. So if someone does come in with any criminal issues, you'll need to ask them to get certificates of disposition before they can submit an application, if they are able to submit at all. Once a DACA is submitted, the requester will receive a receipt notice from USCIS within a few weeks of filing. So this merely confirms that USCIS has received the application, and it gives the requester a case number which they can use to check the status of their case online. In some cases, the USCIS may send a notice, a rejection notice, and that may occur in cases where the fee is not sufficient or the amount on the check is not appropriate. If, as I said, it's even $1 off, it can be rejected, and for reasons like that. But generally, you'll get a receipt notice that just has the receipt number. The requester will also receive a biometrics appointment, which is also a fingerprints appointment. It's very important that the requester goes to this appointment. If they miss it, there is potential that USCIS will consider their application abandoned. So when they do go to this appointment, they do have to bring their appointment notice and also some sort of photo identification. Passport is best, but state IDs can also be used. In some cases, USCIS may request additional evidence or an interview. So this is called a request for evidence. And in this case, it's very important that the requester responds to any requests for more information by the deadline noted in the request. If they fail to do so, their application will be rejected. So generally, the processing time for a DACA application is anywhere between 4 and 6 months. It is important for the requester to understand the consequences of lying on an application. An individual who knowingly makes a misrepresentation to the Department of Homeland Security or knowingly fails to disclose facts in an effort to receive deferred action or a work permit will be treated as an immigration enforcement priority. So this can mean criminal prosecution and or removal from the United States. And a misrepresentation includes submitting fraudulent documents, lying about dates or eligibility criteria, or omitting information such as criminal history. This will not be an issue for many requesters, but if there does seem to be any inconsistencies in a story or things don't seem to match up, please speak with a supervising attorney who can assist you in how to proceed with the application. It's really in the best interest for the applicant to be honest, and even if it means that they're not eligible for the deferred action, it's better for them to not apply than to be caught making a misrepresentation and then potentially be deported because of that. So now I'm going to talk a bit about travel outside the United States. A DACA requester cannot travel outside of the United States while their application is pending. And even once deferred action has been granted, a requester cannot travel abroad unless it is for a humanitarian reason, educational reason, or employment reason. In those cases, the DACA recipient must apply for advanced parole before leaving the United States. So this is asking for permission to leave the United States. To apply for advanced parole, there is a filing fee of $360. A DACA recipient should speak with an attorney before traveling abroad, even if they are granted advanced parole, because there may be issues that would prevent them from re-entering the country. So that there could be some admissibility issues if they have a criminal history, unlawful presence, medical ineligibility. So the advanced parole does not guarantee that someone will be allowed to re-enter the country. So it's important to advise requesters if they're asking about travel outside the U.S. to consult with an attorney before they leave the country. So you can find more information on the USCIS website and the NYLAG Deferred Action Assistant Program resources. I've also included the required forms, the memo from Janet Napolitano announcing DACA, and a list of frequently asked questions from the USC website. It should be in the folder that goes along with this webinar. If they've not yet been added, they will be by the end of the day. So now there'll be a bit of a time for question and answer, so if there are any questions, please let me know. Okay. I'm done. Okay, there don't seem to be any questions now, but I'm just going to review, kind of go back a little bit to make sure you can get your CLE credit. I'm going to go back to a bit more about the supporting documents. So if you'll just go with me back. Okay, so as I mentioned earlier, it can be a bit difficult to show the continuous presence in the United States since the June 15, 2007 date. And some documents that you can use, you need to be a bit creative with it. So I think I already mentioned using school records, medical records, even phone bills, cell phone, tax returns, bank statements, credit card statements, pay stubs, any travel records within the United States. I think I mentioned marriage or divorce certificates, children's birth certificates, if there were any court appearances, proof of baptism or any religious records or military records. These can all be used to show presence. It is just very important to make sure that that we can prove that they've been here for that 5-year period since June 15, 2007 up until today. So not just for the 5 years from 2007 to 2012, but even up until 2014. We ask for 2 items per year, but I like to ask clients to actually provide a bit more. Maybe 3 or 4 a year if they can. I've had clients use receipts even from MoneyGrams when they've sent money back to their home country. Or I have used Facebook, as I said already, possibly emails that might have location in it, things like that. So if you can get 3 to 4 a year, that is the most helpful for the applicant. I think with that, I'm going to end the presentation for today. Unless there are any questions, I thank you very much for listening, and we look forward to having you at our clinics. Thank you. Oh, and one last thing, let me just give you my contact information if there are any questions. My phone number at NYLAG is 212-613-6572, and my email is nlucak, NLUCAK, @nylag.org. Thanks so much.